Action from the closed session. We'll go on to educational presentations and committee discussion. First up is Marathon County Assembly's Ordinance Draft 12.04, and Shad Harvey from CPZ is going to present for us. Thank you.
Yep, perfect. Thank you. All right. So I know this committee has heard kind of this presentation before, but it's been a little bit, so we'll kind of run through the presentation, and then I'd be happy to address any questions. So this is about the 12.04 Large Assemblies Ordinance update. So just kind of getting back to the reason for the update, 12.04 originally kind of put in place in the 80s is currently unenforceable due to possible constitutional concerns. A lot of those concerns are with the time frame on when permits would be issued for assemblies. And the county board did place this on the administrator's work plan. So just to give a little bit of what has happened. A work group was essentially developed to try and work through this and develop a ordinance that is enforceable. Work group members included Steam Show, Taste and Glow representatives, Dairyland Balloon Jubilee, Environmental Resources Committee, members from Public Safety, Infrastructure, and then as well as county staff from CPZ, Emergency Management, Health, Parks, Rec, Forestry, Highway, and the Sheriff's Office. So the timeline that this has currently been through, the work group originally organized in June of 2023. Through that, we've kind of went through the process of distributing drafts to town, trying to get public comment, presentations at towns associations, drafts in November and January of 2024, and then kind of cycling through. We're kind of back doing our rounds. Some additional edits were made to the security section with the hope of the standing committees and county board deciding whether to approve or repeal the ordinance. So right now, like I said, there is a current ordinance in place that's currently unenforceable. So we would ask that, if the committees or the town or the county board were to say no to this ordinance, that current one would be repealed. But right now, this is just an educational piece. So we're likely going to bring this back in front of the standing committees next month for that decision. Yeah.
Are you going to be at the Towns Association in January and just, because the only thing I don't want to see happen is have a town chairman come in here and say he doesn't know anything about it. When at least there, one more time, bring it up and just, I want to see some input from them if they have it.
Okay.
And act like, I don't want to see somebody come in here and at the last minute and say, I didn't know anything about this. And I understand they have a different opportunity. Maybe try to get their input, I guess, just so we know where we stand.
Yeah, I know we've done some extensive reaching out to the townships, whether that's just the general emails, but we also have called the towns. But yeah, I think that's something. I know there'll be members from our office that are going to the Towns Association meetings as well. So just some summary of the input that we have received. A lot of the summary came basically due to the purpose of the ordinance, the threshold and applicability of the ordinance. There were some security concerns, implementation and appeals, and fees. And the PowerPoint got split up a little here, so bear with me. I'm just going to go to the next slide here. So what the work group kind of came up with, purpose and draft of the ordinance is the assembly of a large numbers of individuals in excess of those who would normally be requiring the services of the health, sanitary, fire, police, transportation, and utility agencies, which are regularly provided in the county. The assembly of the large numbers of individuals in excess of those who regularly occupy the event location to minimize adverse impacts to surrounding properties and uses. So that was the purpose of the ordinance. Applicability, so where would this ordinance apply? So this ordinance would apply to all unincorporated areas of Marathon County, so it wouldn't apply in the cities or villages, just the townships. And then why? The objective of the ordinance is to protect people and the resources of Marathon County. And then the copy of the draft ordinance is in there, and I do have some other slides that are kind of stuck underneath here. The other thing that was discussed is the threshold for the application. So when would a assembly need to kind of get a permit? The work group had discussions and stuck with what the current 12.04, so what's on the books right now, did have 3,000 as the threshold. They did clarify it a little bit, so it's 3,000 or more in any one time or an aggregate over the course of 8 consecutive hours. And then there are some exceptions in the ordinance as for when this permit essentially wouldn't need to be required or wouldn't be required. So established places of worship, stadiums, athletic fields, arenas, auditoriums, coliseums, businesses where the primary product of the said business is providing that event space. That area must be, those businesses must be correctly zoned and have all the necessary permits for this exemption to apply. And then fees shall not apply to government-sponsored events held on government-owned property where the proceeds are returned to the government or community, nor to assemblies required to be licensed by other laws, rules, resolutions, or ordinance and regulations of Marathon County. This does not exempt organizations from any other local regulations or zoning ordinances in effect where that event is taking place. So if there's local zoning that might have a say, they would still need to get those approvals as well. Some of the other stuff, security concern. So this is one of the things that was changed kind of on the new draft, or I should say edited. So essentially there's the private security requirement for events. There's 2 options, private or contract with the sheriff's office. So if you're going the private route, essentially the ordinance requires 1 or 3 security three security personnel for every 1,000 individuals on site. That doesn't necessarily mean that somebody has to go out and hire a private security firm or anything like that if they're going the private route. The only requirement they can be volunteer. The only requirement is that the individuals designated as security have a background check and are registered with the state through DSPS. And there is a link that's in the ordinance for people's convenience where they can kind of click on that and get to that link to get the registration completed and the background check. Again, this ordinance is meant to address both known and unknown events, so it's not just necessarily for the events we know are in the county, but more or less a planning tool for the events we don't know that are going to pop up, just making sure it's safe and making sure that they're thinking of the things that go into event, bathrooms, security, things like that. Implementation of the ordinance. So we did develop an FAQ, and that is included in your packet. It's kind of stuck between the slides there, and we can get you guys clean copies as well. But resource guides, example plans are available for an applicant that's going through the process. To try and make this process as smooth as possible, CPZ is already kind of set up to intake permits and whatnot. So all of the permits, CPZ would be the contact for that, and then we would be responsible for distributing that to the other county departments that would be necessary for that permit. Health department permits, they would remain a separate application, but CPZ would work with the health department to kind of coordinate that. So it's still essentially one contact for the property owner, making sure they have one point of contact so they don't have to bounce around a bunch of different departments. And then there is a suggestion in there to evaluate the ordinance after 5 events. Originally, we were thinking about, after a year to reevaluate, but we may not have that many events within a year. So we felt that it'd be better to analyze the ordinance after we have enough of test data or individuals going through the process to see if anything needs to be adjusted. So the issuance and appeal process. So this is the kind of going back to the original ordinance that's on the books right now. One of the constitutional concerns was the time frame in which it would take to get a permit. So the applicant in the new proposed ordinance must submit at least 40 days prior to the event. CPZ would make a decision to issue or deny the permit within 30 days. And then there is also an appeals process. So the individual, group, or organization to whom the license has been denied may appeal. A township in which an event is intended to take place may appeal. It must be submitted within 5 days of the permit issuance. So yes, that's a pretty quick turnaround. But again, we have to keep in mind the timeline in which a permit decision needs to be made. So the appeal process is they would submit that appeal, and then the administrator would make the decision within 5 business days. And that's to kind of keep that permit in line with that 40-day timeline. So ultimately, CPZ would have 30 days to review that permit, and then we would notify towns that the application was submitted and when a decision was made, whether it was approved or denied, which would give them the opportunity to, if they felt they needed to appeal that decision, to reach out and appeal. So fees and recovery, the applicant would submit a fee with the assembly permit application, and then recovery of fees. So if the event requires county-owned materials and staff labor, they would negotiate with that county department via separate contract for those services to make sure the county is getting reimbursed for the extra services that they provide. So kind of the next steps, again, this is education, so a decision isn't made today. But the next steps are determine if the committee wants to take action to move to the county board for adoption. And there's kind of, if adopted by the county board, the date the ordinance would need to be included in the resolution. So when this ordinance would become effective, we'd have to include in the resolution. So again, it's really, the next steps are kind of bringing it back to the committee likely next month for a decision on whether the standing committee would want to pass this on to county board or if they choose not to. Any questions? And we'd be happy to talk to you about the ordinance too at a later date, but any questions, yeah.
Supervisor Hoppe.
If you could use the microphone, please. Yep.
Since, is it on? Yeah. What would be some reasons that people would be denied the permit?
So the reasons would be exactly what the ordinance is intended for public safety and just safety in general. It wouldn't be able to be denied for, what the event topic is or anything like that. It would likely have to be due to a safety concern or not meeting the criteria listed in the ordinance. But it couldn't be based on the topic of the assembly.
And people are given the fee structure if they use county facilities or, our services at all? They're giving that in advance, right? The amount?
So that would be something they'd have to work out with the department that offers that. They'd have to get that determined, and CPZ can help facilitate those discussions too. If they have questions on stuff like that, we can kind of get in contact with the right people to figure out what the charges might be, depending on what they're asking to do.
Okay, thanks.
If I could just add, the primary one that I'm sure Shad went through when I stepped out, but law enforcement has been, if you always think back to what kind of spawned this discussion quite a number of years ago. I know Chair Mask was around when we started having these conversations. We were just getting a lot of requests for events that were outside of events that might be at Marathon Park that our Parks Department already has a process in place for event rentals or things like that. But these are events out in perhaps a town, and there was an expectation that law enforcement and or highway department staff, those were the two primary ones, would be asked to do things like either traffic control or be out there for safety reasons. And as Shad said, the understanding, the expectation with the new ordinance is if you are looking for, again, best example is we want the sheriff's office, I'm going to run an event and I would like the sheriff's office to fulfill my security obligations, my security responsibility under the ordinance. I can do that, but to do that, I would have to have a conversation with the sheriff's office staff to say, what is that going to cost? Because the idea, again, one of the underlying principles is we're not using county tax dollars to subsidize events. There are certainly parts of our work that are normal business that we do, and the sheriff's office does normal business, but that
Okay,
normal
we have
business.
to stop the meeting. We don't
Oh.
have a quorum right now.
I didn't have anything important to say until he comes back anyway.
We're kind of short-staffed today. My mentor here. I'd be so embarrassed. Okay, we have our quorum back now.
All right. So as I was saying, the difference with the ordinance that it requires for those services, what we call extraordinary, they're outside of our normal work. So if you're running an event and you want the sheriff's office or the highway department to do something specific to support that event, the guiding principle has always been from the various committees in the work group, that should be governed by an external agreement between the county and the event holder, with the idea being, again, we aim for cost recovery. So, thanks, Shad.
Any more questions or comments? Okay, thanks, Chad.
Yeah.
Okay, we'll move on to the next educational presentation, a reflection by our outgoing district attorney.
Oh, I think you got her.
All right. Yay. Good afternoon, everyone. This will be the last time I address you all as the district attorney. So that's pretty exciting in many different ways. It's been an honor and a pleasure to represent Marathon County as district attorney. And I guess, you know, I don't know how many people know kind of the track to get to this point, but when I was elected in 2016, I had already been the deputy district attorney since 2006. So I had been in management at the DA's office for 10 years. Many of you know, who've been around for a while, that turnover has been a big issue in the district attorney's office as far as prosecutors are concerned, and understaffing, things like that. So I went through some really bad years at the DA's office as management where I couldn't even tell you how many job interviews we have conducted at the DA's office. So when I went into the role as district attorney, when I was privileged enough to be elected, I knew myself, and I knew that 2 terms was what my goal was, and for a couple of reasons. I am not a politician. I do not believe that partisan politics belongs anywhere near the district attorney job. I do not like to engage in politics. I do not like to have that give and take, because I think the justice system and the role of district attorney should be immune from that. And so it's very difficult to maintain that status or that attitude for a long period of time in an elected position, and I was realistic about that. I also was realistic about where I was at in my career, as far as the toll that this job has taken on me in management. And I knew that you have to be self-aware that if you're getting to a stage in your career where you feel yourself burning out, you shouldn't wait until you actually burn out to make a decision to move on. You should make that decision before you burn out. So there was a lot of discussion in our office about who might be interested in running for district attorney. We have our DA-elect back there, Kyle Mayo, and there was a very healthy discussion in our office before he decided to run. And this is my dream succession plan. He's a Republican, for example. I'm a Democrat. And that is wonderful. I fully support him. I will not be on any committees for at least a year. I will not be involved in speaking for the DA's office in any kind of way. This will be Kyle's office, and he needs time to develop his platform or put in place his platform. He doesn't need me in the way. It is no longer my office, and I am completely accepting of that. So I just wanted you all to know that. And a lot of the decisions in the last probably 3 months especially, I've run those by, I should call you DA Mayo, not Kyle, him, and made sure that what the position I was taking was aligned with his, or I would step back and have delegated that decision to him, because the last thing I want to do is make a decision and then have him overturn it in a couple of months. So it has been it has been a wonderful transition, and I really appreciate DA Mayo, the elect Mayo, for that. So I wanted to do, this is sort of my closure, and I had a lot of fun putting this PowerPoint together because it reflects the tremendous growth that we've had in the DA's office and as a system in collaborating. I see the sheriff's office here. We've had a lot of collaboration with you over the years, and we made some really positive change. So I'm happy to go through this, and it really is 8 years in review. And I just want to congratulate myself for doing an animation in my transition of my PowerPoint. That is really big stuff. So prosecutor staffing, look at this. Prepare to be amazed. Woo! Ruth, are you so proud? So in 2016, when I was elected, the workload analysis showed that we need 6.1 prosecutors and a total of 14.6. We had state funded 8.5, county funded 2.5. In 2024, we have 13 state funded prosecutors. That is wonderful. And we also have an additional state ARPA funded prosecutor that sunsets July 31st of 2025. We are very hopeful that the state will make that a permanent position. So we have had that position filled since January of 2023, and we have maintained that position as a full position, and it's been great. We are fully staffed and have been fully staffed. So when I approached this position, the other thing that I really wanted to do was take a really hard look at how we were running our office, what our workflow was, and I wanted to have an office where everyone felt empowered to bring forth ideas, have a continuous improvement mentality. I really wanted people to, whether you're a legal assistant or a victim witness specialist or a diversion specialist, everybody could bring forth an idea and ask why. Why are we doing this? How can we do it better? But I did not want them to bring forth problems and complain. I wanted them to bring forth problems with proposed solutions. And I am amazed and so grateful that our staff has really stepped up. And a lot of these improvements that I'm going to share here today are a result of an amazing staff, all the way from legal assistants to victim witness to attorneys and diversion. It's been amazing, an amazing journey. So we were opening about 5,938 files in our office, and we had all these rolling shelves, and they took up office space, and they were frankly dangerous because somebody would roll the shelf and somebody be in between and they wouldn't realize, and incredibly inefficient. We would run around our office trying to find the paper file. People would freak out because you couldn't find the file, something fell out of the file. And so in 2017, when I took office, we went paperless. And let me tell you, that was a task. And it actually went fairly smooth because we planned. And everybody was involved, every aspect of the office. So we are completely paperless. The only time you'll see us carrying around papers when we're going to trial and we have a binder, because sometimes that's easier. We also instituted a preliminary hearing testifier. So at preliminary hearings, what we had been doing, that's the first stage of a felony case where testimony is taken to show that we have enough to go forward with the case. The state has enough. What we had been doing is we would subpoena law enforcement officers. So we could have 10, 20 preliminary hearings on any Wednesday or Monday morning. And the officers would be, whether they're on night shift, day off, it doesn't matter. They would be subpoenaed to come in and testify. Two things were a negative result of that. We were impeding them from having normal lives, and we were costing the departments a tremendous amount of money. So we met with local law enforcement and pitched the idea of us hiring a part-time retired police officer to do all the testifying in those cases, because hearsay is admissible. And law enforcement, depending on how often their cases were being testified to by that preliminary hearing testifier, they would contribute to the cost. So it wouldn't be any tax levy burden on the county. And it has been a tremendous success. And we don't keep the cost savings anymore, but initially, that data we don't keep anymore, but initially it was $165,000 to local law enforcement in those first couple of years. So I'm sure it has either maintained or grown since then. We also instituted an operating without a license or operating after revocation program. I know I only have 15 minutes, don't I? So I'm going to rush it along here. But I just want to say how that also was an idea born out of diversion and our staff. So we wanted a process by which it was inclusive. So when you have different prosecutors reviewing different files, they have different levels of knowledge on how to read a driving record, for example. So we wanted one individual, highly trained, to evaluate driving records at the point before they're charged. And if there was any opportunity that individual can become licensed, validly licensed, we would pull that case out, not charge it. And we wanted a program where we actually could work through with them getting their driver's license back. And our outcome would be that they would be have a valid driver's license, and they wouldn't come back into the system. But we needed it to be a productive program, because what was happening is these cases would go to court. They could never get a valid driver's license. We'd have pretrial after pretrial, and they'd say, well, I'll come back with my license the next time or the next time. Now, if they come to court, we know it is because they've either failed that program or they can't get a valid driver's license, and it makes those cases should be very quick. You're either going to plead and take accountability, or you can have a trial if you'd like, that's your right. But we have all that information up front. That has also been a very successful program. Reduces time in court, reduces recidivism, and it lowers the general cost to the county for those types of cases. We also instituted a 10% surcharge for restitution collected as a result of our pre-filing diversion, and then a $75 fee for diversion cases. We weren't charging any fees for our diversion program, which has been in place since, I think, 2006 or 7. So that was 2017. Wow, I made it through 1 year. Okay, 2018, with the support of the county, we received funding for an IT specialist in our office. This is so critically important with the number of agencies that we have to quickly process digital evidence from those agencies while body cameras, and we really got out in front of this because now body cameras are, I believe, in all of our agencies. So he is processing 15,000 digital files per month, 1.5 terabyte worth of data. For those of you who have no idea what that means, that's equal to about 900 high-quality movies that he's processing and downloading from different files. And on average, that's about 365 cases per month. So he is the central person. By centralizing that, he itemizes all of the digital data that he provides to the defense for easy access. He troubleshoots issues. He'll work with defense attorneys who don't know how to play the data. He'll make sure that our attorneys can play it. He also works on closed captioning of interviews so that jurors can, if they can't hear what the person is saying, they can see it. He helps get those interviews transcribed if they're in a foreign language. He works with 9 different types of data that he listed here, but I'm sure there are more actually than this. But when you take the body cameras, for example, different agencies have different types of body cameras. It is a full-time job and then some. We just did evaluations, and repeatedly people said there needs to be more than one person doing that, but that's DA-elect Mayo's job. So it has been a tremendous success, and we are in the forefront of that, and a lot of other counties are trying to follow suit because they see the utility of this, and it is, if you process cases faster, that's less days they spend in jail, that's less days that they're out on bond, and less adjournments, and so on and so forth. So it is definitely a good investment. When that came along, we had no idea that we were going to have a pandemic. And I love this quote. I went back through all the budget messages since 2016, and I really thought that this was a great quote. And it talked about the office is essentially paperless, has streamlined its discovery provision process, as one of the most successful offices in adopting telework during our pandemic, due in no small part to him. And that's true. We were able to keep working, and without, except for jury trials, we really didn't have much change in our output because we were paperless and we had an IT specialist. 2019, we got, through support of the county, a diversion specialist. Again, that is forward thinking. It's not a mandatory program by any means. It is a discretionary program that the county supports. But by doing pre-charge and post-charge diversion, we're either keeping cases out of the system, or we're intervening in a manner that hopefully someone won't have a felony charge if they comply with the terms, and we're helping victims collect restitution more effectively in the cases that these agreements are appropriate for. And we've collected over $1 million in restitution through those programs, and we have a very high caseload, and it is, I believe, the largest diversion program in the state of Wisconsin, even larger than Milwaukee. And we are monitoring regularly the recidivism rates to ensure that we are picking the right cases to go into that program, because the worst thing you can do is create a program and not have the outcomes that you want and actually be doing more harm or negatively impacting public safety. Also in 2019, I was fortunate enough to get the Wausau Police Department Public Official Partnership Award, which I was very honored to receive. So 2020, we had the electronic transmission now of discovery, one of the first counties in the state of Wisconsin to do that. I think we were a pilot program to do that. It's a free transmission service where we're able to send all these recordings and even the paper discovery to defense attorneys, which is an integral part of the system. We can send it all electronically. That hit right before the pandemic or during the pandemic, and what great timing that was, because we were able to continue working and getting the defense attorneys the information. Marcy's Law hit right during the pandemic. The Constitutional Victims' Rights Amendment, we were able to strategize even when we were working remote to ensure there was victims' rights compliance. It is in 2020 that we eliminated our receptionist. For those of you who haven't experienced our intercom, it's wonderful, and our phone tree, but we made a very difficult decision to eliminate our receptionist and add a victim witness specialist, because it was clear that the state of the budget was not going to allow us to get that position, which we absolutely needed, especially in response to Marcy's Law, and keep a receptionist. We also eliminated a legal secretary, and instead of adding a paralegal, we changed the position from the duties from legal secretary to paralegal. This was a very difficult transition in our office, and one of those situations where having your staff understand the need, having them participate in the conversations, and having them buy into the need for this transition was incredibly important, and we were able to keep our staff through that and continuity, and it has been very successful. We also instituted the arrest proxy tool in conjunction with the Marathon County Sheriff's Office and other local law enforcement. This was another eye-opening experience. We found out through this process that individuals were being arrested on low-level offenses and bonded out from the jail because law enforcement, frankly, didn't want to wait for the DA's office to issue charges, and they wanted those cases addressed more quickly than the year or 6 months that it would take to charge. So they were arresting the individuals so they'd be bonded out for a quicker date. Well, that was something we needed to change, and with our new processes, we took it down from a year or 6 months to 30 days, or within 30 days that we act on cases. Law enforcement agreed to try citing or summoning people in instead of arresting them for lower level offenses. That saves bookings in the jail during a pandemic. That was really good. And going forward, it just makes sense. So it really took that conversation to say, hey, you guys are contributing DA's office to that issue, and we looked at the whole picture, and it made sense for us to change how we were doing business, have a higher expectation of our charging, and law enforcement then was willing to change their process. Chad, I would say that's been a success. And a work in progress. Always, you have to constantly evaluate, right? I think that's true. Constantly evaluate. But the concept was an important one, I think. So in 2021, I put this slide in here because I think that this is, and I hope that this is a topic for future conversation, is the system budgeting. So in 2021, we were seeking a legal secretary position. And at that time, if those of you who've been around for a while might recall, what often ends up happening is programs get pitted against each other. And it really, at the county board level, it's really a pretty awful and uncomfortable situation. And I'd rather not have DA-elect Mayo have to go through that. I would rather that we go back to what we talked about in 2021 and make that a priority, and have a system budgeting approach to the criminal justice system where the people who are involved in the system really can be the decision makers and then present that to the board as a policy board to make those decisions. I put the renovation of the reception area in there because that is kind of a sore spot for me. And I hope that with the movement to North Central, I just wanted you guys to know that's been on the table for a long time. So next year, when that becomes a topic of conversation again, that it could get some support for moving forward with the moves to NCHC. 2021 also was the Yeetus homicide, which got a lot of publicity, I guess, good or bad, for Marathon County. And I was fortunate enough, in part from that and other things within the office, to be chosen as the Wisconsin District Attorney of the Year in 2022. Again, this is a system budgeting, and I wanted to reemphasize how important I think that is going forward. 2022, we, with the county support, did add a legal assistant position. We also did a new discovery process where all that data that we were talking about processing, again, we became a leader in Marathon County as far as charging by the data set for discovery. The process that we have in Marathon County, I often get complaints that we're charging too much, but I will tell you that the process that we have and the manner and the service that we provide in that digital discovery is pretty unmatched in the state of Wisconsin. We have other counties that don't even put numbers on the bottom of their discovery. They don't itemize any of the digital discovery. They certainly don't troubleshoot. There are all kinds of things that we provide with that service, and that's why that cost is what it is. We provide a quality service, and it saves in delays and other things in the process. We also partnered with the Lawyer Assistance Program. As I stated, turnover in the office had been very high, so we worked with the Lawyer Assistance Program, and I'm happy to report by 2022, the DA office staff reported 96% felt that they were supported in the office, which was a huge turnaround in the culture of the DA's office. In 2023, we received 2 state ARPA-funded prosecutors. Like I said, one of them has been filled continuously since January of 23, and the county is supporting a ARPA-funded victim witness specialist. We transitioned a deflection program from North Central Healthcare and overseen by the Sheriff's Office to the DA's office. And we started doing more local law enforcement training. Again, our staff saw a problem as far as getting real, when we had that prelim testifier, we took away opportunities for law enforcement officers to testify. So now they weren't testifying as much, and they were struggling when it was time to testify at a trial. So we instituted a local free training where our attorneys put it on. It allowed us to collaborate with local law enforcement for them to see us all day It's free. They don't have to go anywhere. It's right here. And we're in the courtrooms, and we give them vignettes, and they actually get up there and testify in front of their peers. They get critiqued. We also show them experienced testifiers and how they would handle the questions. They go through cross-examination. There's a lot of prep work that goes behind it, and there's also an education component for 4 or 5 hours in that as well. And that's been very well received. We also had our first comfort dog in the DA's office to support victims of crime and witnesses who come in who are really struggling with the trauma that they've experienced. And we instituted a wellness committee, which is a multidisciplinary committee within our office who meets regularly to put on events for our staff. They do this in their time away from their core job duties. They must fulfill their core job duties first, and this is in addition to that. By choice, they participate. And with that, we were able to secure free monthly therapy sessions for our staff. We had an individual who comes in, we still do, comes into our office on a monthly basis and will meet confidentially with our staff and talk through whatever it is that they need. It has been very well received by our staff. 2024, we're continuing with victim witness ARPA funds. We're fully staffed with no prosecutor turnover for 2 years. Our deflection program is flourishing, and we are getting very positive feedback from our law enforcement partners. That is the program where we're dealing with high risk, high need, usually substance addicted offenders who are identified by law enforcement when they're having contact with them on the street and they're ready for treatment. They need it now, and law enforcement has the support of the deflection specialists from our office to make that happen. They will drive someone 4 or 5 hours to go to treatment, and it's grant funded, and it gets them in, and then they are part of the deflection process from there, and our attorneys help support that as well. And I was also fortunate enough to be named the Mosaic Woman of Vision for 2024 for alternative programming and addressing staff issues. This is, I think you guys all know this already, but the deflection program has really been a breath of fresh air where we feel like we're making meaningful impact on this population of drug-addicted individuals. We have a tremendous deflection specialist who goes above and beyond to grow this program, and her supervisor, Ruth, is back there, who is extraordinary. 25, we will have continued ARPA funding for the victim witness specialist. We also transferred our investigator over to the sheriff's office. That was also discussion of collaboration, and we let go of our investigator. Our investigator was a DA's office employee, but people started to talk about what we could do with that position, the investigator included, if we had that person as a full-fledged deputy with the sheriff's office. It takes a tremendous amount of trust to say, here's sheriff's office, here's this deputy who's going to be placed in our office. What secures it is an MOU and trust. And I think it's going to be a wonderful change to use that position, to give that position, whoever holds that position, some opportunity for growth, and we get better quality service through investigations as well. So I appreciate the sheriff's office for that. And then we converted 2 legal assistants to paralegals. That came out of a process where our office staff got together and really determined what we needed. And again, it was a positive experience because no one got territorial. Everybody looked at what was best for the office and case processing and agreed. And so we made that transition, and I had told my staff a couple of years ago that was my vision. And so people went back to school, they got their training, they put themselves in a position when that happened, they would be ready to be hired on at that higher level, and that's what happened. So one person already had it, but the other person got the training. So these are kind of the 4 tenets that were my guidelines, I guess, as district attorney. And I've come up here and spoke to you many times, and I've talked to you about programs that I had concerns about. I've talked to you about different issues, and at the forefront is public safety, accountability, victims' rights, and efficient resource allocation. And I hope this presentation shows you that I had high expectations for our office, for accountability for our office and growth of our office. And when I came before you about programs, I was trying to apply those same standards to programs outside of our office that our office was a part of in the criminal justice system. And that is the place that I came from when I was bringing up issues with programs. And so some people have really formed opinions about me based on my strong statements about some of these programs, but I want to let you know that I did a lot of homework on these programs. I had a lot of conversations on these programs. There was a lot of background work before I ever came to this committee with a presentation. As you can see from the things that we've done in our office, I have no reason to try to destroy a program. I want to make the programs better. I want to make them consistent with public safety and accountability. And if I see an issue with a program that I think is not consistent with those 4 tenets, I am going to speak up. And I try to speak up individually and directly initially, and then I try to speak a little louder, maybe to a different group if I get no response. And then eventually my voice gets really loud. And unfortunately, that's what you see, is the end result of many, many conversations that have occurred prior to coming to this board. And so I just want you to keep in mind that it should never get to that point, in my opinion, that I'd be bringing you these issues. They should be resolved many conversations before. But I believe it's my job. And if people have formed opinions of me that are less than positive, I bet they're talking about these programs, and that's okay, because that's what I want. Review of these programs, evaluation of these programs, and if that's what it took, that's fine. So one of the things that does need attention, and that slide earlier was in 2021, is restitution. I feel that was one thing. I had a list of things I wanted to accomplish. That was one thing I did not accomplish. Restitution, if a person is a victim of crime and there is some kind of harm to them, let's say their property is damaged, and the person goes on probation and the court finds they have to pay $5,000 in restitution. If the Department of Corrections, while the person's on probation, doesn't collect that $5,000, which can be very important to people, $50 can be very important to people, at the end of that probation, it gets converted to a civil judgment. Right now, our system requires that victim to collect directly from that offender through the civil judgment process. Meanwhile, court costs and everything else is being collected through the clerk of court's office through their debt collection system. So the court costs will get paid before the civil judgment often. And if you have a victim of crime, let's say a sensitive crime, what, you're going to have that victim reveal their address and make direct contact with that offender to collect? It needs to be changed. I'm not standing up here saying I have the solutions. I have proposed solutions. There are counties that are doing it, and it might be a matter of investing in additional staff. I don't know. But I really would like to see an evaluation where the clerk of court's office is the collector of restitution so that we are truly assisting in accordance with the law, for one, and in accordance with Marcy's law and victims' rights in that collection of restitution. SSTOP 2019, I brought an issue forward on that. We have not been participating as prosecutors in that program since 2020. We are still funding that program. Those of you who don't know what that program is, I just point out to you that that is concerning because that is a program that we fund in the criminal justice system. And I don't have time to go through it all here, so I won't. Pretrial services, that's another program that we fund. I hope that we can have some more accountability for that program and whether it's providing the outcomes that we hope that it would, which is individuals showing up to court, not having as many missed court appearances. I think there was a a thought that there was drug testing occurring while people are on bond. That is a very, very rare case, as I understand it. I think there needs to be some real discussion about that program. And I'm not going to rehash drug court because you all have heard my concerns with drug court. We are not participating. OWI court, I think, was a symptom of a greater system issue. Maybe system budgeting is part of it. But I just want you all to know that before I lost my cool about OWI court, I had 4 years of trying to get that money being used wisely and to get a vision of what that court was going to be, because we have a prosecutor who was on that court, who loves that court, by the way, is very sad that it's going away. She really believed in that court. And, it's hard as the district attorney to hear we have no money and to hear we can't request positions or we can't do this or other priorities within the system, and to know that that program for 4 years after the law changed was shrinking. And where is that money going that the Public Safety Committee and the board had earmarked for that program? And I kept asking the questions, and eventually I got mad about it, and at least now people are talking about it. So I just don't want it to get to that point for DA-elect Mayo's sake. I hope that we can find a better way to have the tough conversations, to decide a leader for these initiatives, all sit at the table and have the tough conversations and look at what's best for the system. I have been told during this process to not tell other people how to do their job. And I hope that that mentality never comes out again, because that is so dismissive and not understanding of what it is that we're trying to do together as a system. Voluntary appearances, I hope that, and bond forfeitures, I can't get into all of that right here today. I just put those topics out there for hopefully some future discussion. If people miss court, it is a tremendous cost negative to our county, and people in the system run around, and if they say they can right now, if you miss court, you can call up and say, I would like to appear in court tomorrow to quash my warrant. People run around, get the information together, we call the victims to say so-and-so is showing up for court tomorrow, and guess what? Then they don't show up. And then they can make that same call the next day. My ask was that they have to report to the jail. If they reported to the jail, then they would bond out and they would get a date certain, and then everyone would know what that date is, and it's accountability for missing court. And so I hope that we look further at that process and look at it as an efficiency, an accountability, public safety, victims' rights, all wrapped up in that process. Same thing with bond forfeitures. If you miss court and that bond, either a signature bond or cash bond, is there and it's forfeited, that goes to the county to recoup some of the costs for that missed court. Think about everybody who shows up at a court appearance. Defense attorney, court reporter, judge, prosecutor, victim witness, they all show up at court, and the victim oftentimes. If the defendant doesn't show, all those people showed up for no reason at all. And then what happens is that hearing still has to happen at a later date. And then often what happens is when the defendant doesn't show, the attorney withdraws. We've all heard about the attorney shortage here. So if an attorney withdraws because their client doesn't show up, we have to start all over with a new attorney. We have to provide discovery to a new attorney. They have to get on the case, first of all. We have to find one. They have to be provided discovery. They have to review all that discovery. So we repeat all the same hearings depending on how far we are into the system. The victim is experiencing the delay and the uncertainty. It really is a big deal when people don't show up for court. And somewhere along the line, we have accepted as a county that people can just not show up to court. If I don't show up to my doctor's office, for my appointment, there's some accountability. I might have to be charged for that appointment for not showing up. We don't even expect that anymore. Sometimes the bond isn't even forfeited. It's just reinstated. So these are points in the system that I hope we continue to evaluate. And it's not because I want to be harsh or mean. I think we can do better. I really do think we can do better as a system, but we all have to hold each other accountable. We all have to be heard at the table. And we have to not just complain. We have to present solutions. And I believe there is a best practice. There is a best practice for this county. And if we have leaders who can't accept that, then they need to be held accountable for that. So I really appreciate your time. This is closure for me. Thank you for participating in my closure. It has been an honor and a privilege to serve as the district attorney. I will miss it. I will still be here. I will be prosecuting crimes every day in Branch 5. I'm excited. I will be an assistant DA under DA-elect Mayo, and I'll be quiet as a mouse. So I really appreciate you all. Thank you very much.
I can't imagine you being quiet as a mouse. Thank you. Does anyone have any questions for Teresa? Congratulations. And that was a really good review.
Thank you.
I appreciate it. Does anyone have anything? Okay, then we will move on. Thanks a lot.
Thank you.
Next meeting date and time, announcements and future agenda items. Committee members are asked to bring ideas for future discussion. Next meeting is Tuesday, January 7th, 2024 at 1:30 p.m. And I need a motion. Motion from Jason to adjourn. I get a second. And Deb. All in favor? Aye. Thank you. Thank you all for coming. Okay, she just said it's January 14th, not the 7th.
It's kind of a best practice though, here. Well done. That was good. It did highlight all of you.
Well, it's just, it's not. And then I don't know how that got all messed up, but how many amendments?
I think the template, every time it got changed, probably got put it up, and I didn't catch it until this morning.
Yeah.
When I was doing the minutes. Was the second to adjourn, was that Deb, you said?
Deb, yes. All right.
Good job running the meeting.